Yes, it's true. America has banned TikTok, or at least forced its sale. Yes, the country that loves to tout the First Amendment that prevents government intrusion into the marketplace of ideas and allows people to express themselves has just intruded into social media and potentially is going to prevent a whole bunch of people from actually expressing themselves. And President Joe Biden signed the law because that guy loves ice cream and frickin' hates China. All because the app is allegedly a threat to national security. It's such a threat to national security that no one has actually seen the evidence that says it's a national security threat. Representative Mike Gallagher led the charge against TikTok because he believes it enables China to spy on Americans.
It is not a ban. Think of this as a surgery designed to remove the tumor.
Gallagher then resigned from Congress to join an American surveillance firm. And while some of you want to know if this is legal or not, what everyone really wants to know is if TikTok is banned, how will we learn about exciting challenges like licking an airplane toilet seat to get coronavirus challenge? Where will kids find readings of Osama bin Laden's letters to America? And what about all those recipes for NyQuil fried chicken? Well, don't freak out yet. The ban has sparked fierce opposition from TikTok and the 170 million Americans who enjoy the app, some of whom rely on the platform for their livelihoods. So the question is it legal to ban an app or force a company to sell to another buyer? Today, we're going to dive into the controversy surrounding TikTok and the efforts to regulate and ban the app, and whether the TikTok bill is constitutional. Now, if you're older than Gen Z or one of the olds trying to shamelessly pander to the youths, then you might have no idea what all the fuss is about. TikTok is a video sharing social media platform that allows users to create and share short-form video clips on basically any topic. TikTok was launched in September of 2016 by the Chinese startup company ByteDance. When ByteDance acquired a rival app called Musical.ly and its 200 million users in 2017, TikTok exploded in popularity. It's now one of the most popular social media platforms with over 1.5 billion active users worldwide. But TikTok is controversial. Lawmakers in the US, Europe, and Canada have pushed to investigate, regulate, or sanction the social media platform over concerns about data privacy, the spread of misinformation, and the lack of adequate safeguards for children. In December of 2022, ByteDance admitted that its employees had inappropriately obtained the data of 2 American reporters on TikTok. ByteDance used TikTok to get access to the IP addresses and other data of 2 reporters and a small number of people connected to the reporters via their TikTok accounts. After the news broke, the DOJ opened an investigation into TikTok's surveillance of journalists. And lawmakers say TikTok is a threat to national security writ large. They fear that ByteDance and TikTok are secretly under the control and direction of the Chinese Communist Party. Critics believe that TikTok and ByteDance can reveal sensitive user data like location information and give it to the Chinese government, and they point to Chinese laws that allow the government to secretly demand data from Chinese citizens and companies for intelligence gathering purposes. And under Chinese law, ByteDance must allow the Chinese government to take a 1% golden share of one of its subsidiaries. And analysts say these golden shares allow the Chinese government to get directly involved in the day-to-day business of tech companies, including the content that they provide to the public. And like most Chinese companies, ByteDance is legally required to establish an in-house Communist Party committee composed of employees who are party members. In a March 2023 congressional hearing, TikTok's CEO did not directly answer questions about whether TikTok was controlled by China, instead saying that the app was not available in China and that it's headquartered in Los Angeles. And although the feds have been concerned about the national security implications of TikTok for a long time, prior attempts to ban the app died in the courts. But we can take a look at the first of these efforts, which was Donald Trump's executive orders that tried to force a sale. In fact, we did a whole video on that 4 years ago. God, I've aged so much. But in sum, the US government first attempted to ban TikTok back in August of 2020. At the time, then President Trump issued 2 executive orders. The first order prohibited ByteDance from making any transactions with US citizens within 45 days. The second order demanded that ByteDance sell its US assets within 90 days. Both of those orders relied on the president's emergency powers to act on behalf of national security under the International Emergency Economic Powers Act, or IEPA. The IEPA authorizes the president to investigate, regulate, and prohibit certain financial transactions following a declaration of an unusual and extraordinary threat originating outside the United States. Now, 2 separate federal judges, one appointed by Trump and one appointed by Obama, intervened to block the orders from taking effect. In October of 2020, U.S. District Judge Wendy Beadlestone of Pennsylvania blocked the forced divestiture executive order. The plaintiffs were 3 TikTok influencers with millions of followers on the app and who made at least $10,000 a month from short-form videos. Judge Beadlestone held that the government had failed to justify Trump's use of emergency powers to target TikTok. Quote, "The government's own descriptions of the national security threat posed by the TikTok app are phrased in the hypothetical. The government notes that TikTok's parent company, ByteDance, has significant and close ties to the CCP, which could potentially be leveraged to further the CCP's agenda. It states that one of the risks posed by TikTok is the possibility that the PRC government could compel TikTok to provide systemic access to U.S. users' sensitive personal information. The court cannot say that the risk presented by the government outweighs the public interest in enjoining the order when plaintiffs have established a clear likelihood that the identification's prohibitions contravene IEPA. Judge Beadlestone ruled that the government failed to show that TikTok was a pressing national security threat. Then, in December 2020, D.C. District Court Judge Carl Nichols, a Trump appointee, blocked the outgoing administration's attempt to ban TikTok in the U.S. In that case, the Commerce Department had sought to prevent TikTok from being downloaded in app stores and to outlaw transactions between Americans and ByteDance. But according to Judge Nichols, Trump's crackdown against the app was, quote, arbitrary and capricious because the order intended to put TikTok out of business. The judge ruled that the Trump administration failed to, quote, adequately consider an obvious and reasonable alternative before banning TikTok. So with Trump's orders dead on arrival, state lawmakers decided to pass their own bans. For example, in 2023, Montana banned TikTok from operating within its borders. The Montana law would impose a $10,000 penalty on TikTok or any mobile application store for, quote, each time that a user accesses TikTok, is offered the ability to access TikTok, or is offered the ability to download TikTok. And the Montana legislature cited two reasons for the ban: Chinese communism and child welfare. The preamble says that China is, quote, an adversary of the United States and therefore has an interest in spying on citizens of Montana, and the state alleged that China directs ByteDance to share user information, including real-time physical locations of users. And it goes on, quote, TikTok fails to remove and may even promote dangerous content that directs minors to engage in dangerous activities, including but not limited to throwing objects at moving automobiles, taking excessive amounts of medication, lighting a mirror on fire, then attempting to extinguish it using only one's body parts, inducing unconsciousness through oxygen deprivation, cooking chicken in NyQuil, pouring hot wax on a user's face, attempting to break an unsuspecting passerby's skull by tripping him or her into landing face first into a hard surface, placing metal objects and electrical outlets, swerving cars at high rates of speed, smearing human feces on toddlers, licking doorknobs and toilet seats to place oneself at risk of contracting coronavirus, attempting to climb stacks of milk crates, shooting passerbys with air rifles, loosening lug nuts on vehicles, and stealing utilities from public places. And yeah, it sounds bad when you put it that way, but that's kind of a list of a whole bunch of expressive conduct, and you might not like what the expressive conduct is, but that's kind of the point of freedom of expression, right? You can find a whole lot of stuff on the internet or on television that is arguably bad for your health, but that content is mostly protected by the First Amendment. So it's not surprising that several individuals and groups sued to block enforcement of that law. The individual plaintiffs used TikTok to promote their goods and services, and they allege that the Montana ban violated their First Amendment rights to post content on the platform. TikTok also sued on the basis that the Montana law SB 419 infringed on its First Amendment right to make editorial choices over content curation. In response, Montana argued that their law is about child welfare and consumer protection, and that it didn't implicate the First Amendment at all. The plaintiffs sought a temporary injunction barring the law from taking effect while the litigation was pending. And for a preliminary injunction to be issued, the plaintiffs have to show that they're likely to succeed on the merits and the possibility of irreparable harm if the injunction is not granted, and that they'll suffer more serious hardships than the state if the law were not enjoined. And the district court said that, quote, it is unnecessary to precisely categorize SB 19 as a content-based or content-neutral time, place, or manner restriction, because it is likely that the bill is, at the very least, a regulation of expressive conduct that triggers intermediate scrutiny. Now, as we've talked about many times on this channel, often the whole ballgame is what level of scrutiny is applied to a bill. To pass intermediate scrutiny, a law must both, quote, advance important governmental interests unrelated to the suppression of free speech, not burden substantially more speech than is necessary to further those interests, and leave open ample alternative channels for communication of the information. But Judge Donald Malloy ruled that the Montana TikTok ban failed all three prongs of intermediate scrutiny. First, the court rejected the state's theory that it had any claimed interest in national security or foreign affairs. Second, the court found that SB 19 burdens substantially more speech than is necessary. This is apparent on the law's face. SB 19 completely bans TikTok in Montana. It does not limit the application in a targeted way with the purpose of attacking the perceived Chinese problem. Although states do have a legitimate state interest in protecting children from harm, this interest does not include a free-floating power to restrict the ideas to which children may be exposed. And Montana failed to even address the child protection justification in its briefing. Montana also argued that it had a substantial state interest in protecting consumers from TikTok's harmful data collection practices, but the state, quote, has yet to provide any evidence to support that argument, and the court concluded that the law burdens substantially more speech than is necessary. During the same legislative session that resulted in SB 419, the legislature also passed SB 384, the Montana Data Privacy Act, which protects Montana citizens from unsafe data collection practices by social media companies in the state. The Data Privacy Act also applies to TikTok, which means that an outright ban is probably unnecessary to achieve Montana's consumer protection goals. And the court also noted that Meta and other social media apps collected the same kind of data as TikTok, and they sell that data to undisclosed third parties, which harms consumers. And even without a TikTok ban, China could still gather data about people in Montana. They could buy it from third-party brokers, for example. And finally, the court faulted the state for offering zero evidence that TikTok is similar enough to other social media applications that may be considered alternative channels of communication. Now, Montana also had another problem, which was that even if its allegations against ByteDance in China are true, it doesn't mean that a state has the right to regulate foreign affairs. The Constitution assigns primary responsibility for the conduct of foreign affairs to the federal government. Quote, Article 1, Section 10 prohibits states from engaging in a set of activities that implicate international affairs, while the Supremacy Clause, Foreign Commerce Clause, and other constitutional provisions place key elements of this power within the federal government. Though Montana countered that the bill was similar to state laws that criminalize terrorism. But the court rejected this analogy because, quote, terrorism, while it may involve a foreign actor, is not by definition a foreign concern beyond the reach of state law. In contrast, SB 419 explicitly bans TikTok because of its direct connection to a specific foreign nation. At best, the state's comparison is weak. At worst, it is reflective of the pervasive undertone of anti-Chinese sentiment that permeates the state's case and the instant legislation. And while it's true that China has been designated an adversary of the United States, the rest of these allegations could be said about most apps and websites. They gather personal information, often without the person knowing about it, and often against their will. And most people have no idea where their data will be shared because, unlike the European Union, America lacks a comprehensive data privacy law. So it's safe to say that your personal information is already flowing all over the world. So Judge Malloy granted the preliminary injunction and blocked the law from going into effect. However, a Texas law directed at restricting government employees from using TikTok survived a constitutional challenge. Texas banned TikTok from being downloaded on state government devices and networks, citing its Chinese ownership and data privacy concerns. Professors at public universities sued the state, alleging that the ban would hamper their research efforts. But in that case, the federal court found that the ban was a reasonable restriction. The scope of the Texas law was much narrower than Montana's law, effectively only applying to state employees using state devices. And people can still use the app in Texas, including professors who can use it on their personal devices. Though if the US government says that you're a security risk, you're going to need a good lawyer. But if you want a great lawyer, my law firm, the Eagle team, can help. If you or a loved one is suffering from mesothelioma, because asbestos exposure can take decades, if you've suffered a data breach, especially if you got one of those data breach letters, or were involved in a car crash, or just about anything else, we can help represent you or help find you the right attorney. It's so important to talk to a lawyer early in the process to learn what your options are and maximize your recovery. So just click on the link in the description or call the number that's on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle team. The link is down below. But that takes us to the big kahuna, the federal TikTok ban. Congress has finally passed legislation attempting to stop ByteDance from owning TikTok. And as Mike Gallagher alluded to earlier, the federal government insists that it's not a ban because it allows the company to sell the app to a group not controlled by Chinese interests. The Protecting Americans from Foreign Adversary-Controlled Applications Act blocks any app store or website from hosting TikTok or any other app owned by ByteDance. The law prohibits the company from selling the app to a foreign adversary, meaning that Iran, North Korea, and Russia need not apply. The bill also creates a system for users to download their data and switch to an alternate platform. The act allows TikTok to continue to operate if ByteDance sells it within 270 days. The president could extend that time frame for a sale by another year. And obviously, ByteDance intends to fight any forced sale. In some ways, the lengthy period for a forced sale up to 12 months undercuts the government's argument that TikTok is an immediate national security threat. In addition, the bill faces many of the same challenges as the Trump executive orders. TikTok's strongest argument is that the law violates the First Amendment rights of its users and the company. When the government restricts speech because of its content, this generally violates the First Amendment. And the Supreme Court considers laws targeting specific messages as presumptively unconstitutional. ByteDance will argue that the bill is directed at stopping a certain viewpoint, and therefore courts should apply a legal standard called strict scrutiny. When a court applies strict scrutiny, the government must show that the law is the least restrictive means of advancing a compelling governmental interest. It is much tougher for the government to prevail if a court applies strict scrutiny. And adults also have First Amendment rights to receive information. In a 1954 case, Lamont versus Postmaster General, the Supreme Court unanimously ruled that a law requiring people to register with the Postmaster General before receiving communist political propaganda violated the First Amendment. In that case, the post office had withheld a copy of the Peking Review. That was a content-based regulation. And some members of Congress have said that TikTok spreads communist propaganda. That would be a classic example of a content-based restriction. And the TikTok ban could be an example of viewpoint discrimination. For example, after the October 7th terrorist attacks against Israel, American legislators were dismayed by the pro-Hamas posts on TikTok. And lawmakers have a right to disagree with those viewpoints or call them important, but they can't legislate against viewpoints they don't like. However, the government is allowed to restrict speech under a lower standard if that law or regulation is content neutral. Content neutral laws regulate all speech without regard to the message of the speaker. These laws often regulate things like time, place, and manner of certain speech. Content-neutral laws are subject to intermediate scrutiny, which is much easier to meet than strict scrutiny. And the government also says that it has a solid reason for banning TikTok. Kids are being exposed to dangerous content, and the app is a security risk. The federal government can argue that two separate presidential administrations have concluded that China's involvement poses national security concerns that cannot be mitigated in any other way except for banning the app or forcing divestment. And courts typically defer to the federal government on issues of national security. However, the federal law restricts the free speech of 170 million Americans, and the courts will want to know why a less burdensome regulation could not have achieved the desired result. Right now, all 50 states have their own bespoke data privacy regulations, and maybe the TikTok legislation will finally motivate Congress to pass a comprehensive federal data protection law. Now, separately, if you're a constitutional law aficionado, there's one issue that might have jumped out when you saw the specific nature of this bill, and that is the Bill of Attainder. A Kaspersky Lab of Russia and Huawei Technologies of China tried to challenge similar regulations on the basis that the laws violated the constitutional prohibition against bills of attainder. A bill of attainder declares a person or entity guilty of a crime without a trial. Article 1, Section 9 of the Constitution bans such bills. In Nixon versus the General Services Agency, or GSA, the Supreme Court set forth a three-part test to determine if a statute is an unconstitutional punishment. The first factor is whether the law falls within the historical meaning of a legislative punishment. The second factor looks at the function of the law, determining whether the statute serves non-punitive legislative purposes. And the third factor is whether the government's primary intent was to punish. Kaspersky argued that a provision of the National Defense Authorization Act that banned the government from using its software was a bill of attainder. A court ruled against Kaspersky, finding that the ban was aimed at securing government networks from cyber threats. And Kaspersky failed the historical test because the ban didn't affect any person's employment or livelihood. And it failed the functional factor because the purpose of the law was to secure our nation's networks and computer systems from malicious cyber threats. And the ban was rationally related to that important function. The court also noted that the income Kaspersky lost was only a tiny portion of his overall revenue. Finally, the legislative history showed that the government was motivated by a need to protect America from well-documented cyber threats rather than simply singling out Kaspersky for punishment. However, the federal legislation threatening TikTok is more sweeping than the regulations that targeted Kaspersky and Huawei. Those regulations were similar to the Texas state law, which prevented software from being used on state-owned devices. The TikTok ban, though, would stop anyone from using the app in the US if ByteDance doesn't divest itself. Though the biggest difference between the state TikTok bans and the federal ban is that the federal government has a national security interest, and courts give the federal government substantial deference on national security matters. But the evidence that TikTok is a national security threat is classified, and the public has not been able to evaluate that intel for themselves. That's why some like Connecticut Senator Richard Blumenthal, who described TikTok as a gun aimed at Americans' heads, have called for this assessment to be declassified for the public. But what happens next is going to be incredibly interesting if the courts don't strike down the law. ByteDance is worth around $225 billion, and the price of acquiring TikTok would be steep. Then President Trump tried to convince Oracle and Microsoft to purchase the app, but those deals fell through. Other large companies like Meta and Google would probably run into antitrust problems if they tried to acquire the app. And as predicted, ByteDance has filed a lawsuit against the US government alleging that the new federal law is unconstitutional. And not surprisingly, ByteDance is characterizing everything as a ban, saying that, quote, the qualified divestiture demanded by the act to allow TikTok to continue operating in the United States is simply not possible, not commercially, not technologically, not legally, and certainly not on the 270-day timeline required by the act. ByteDance says that even if it did sell the app, the result would be an awkward America-only version of TikTok that would not be commercially viable. The company asserts that a standalone American TikTok would not be able to function without an operational relationship with the rest of the global platform. ByteDance also says that, quote, moving all TikTok source code development from ByteDance to a new TikTok owner would be impossible as a technological matter. And the company alleges that, quote, the Chinese government has made it clear that it would not permit a divestment of the recommendation engine that is a key success of TikTok in the United States. And there have been many technologists that have echoed this sentiment that TikTok simply would not work without the algorithm that makes it all possible, and you can imagine why the owners would not want that algorithm to get into someone else's hands. But this also lends maybe a sliver of credibility to the government's claim that China exerts outside influence on the platform. Though at the same time, if the roles were reversed, you can imagine the US government saying the same thing if China tried to nationalize some American company. However, the complaint is also an invitation to the US government to put up evidence showing that TikTok really does pose specific harm to the American public. Not surprisingly, ByteDance says that the act is an extraordinary intrusion on free speech rights. Quote, by banning all online platforms and software applications offered by TikTok and all ByteDance subsidiaries, Congress has made a law curtailing massive amounts of protected speech. Unlike broadcast television and radio stations, which require government licenses to operate because they use the public airwaves, the government cannot, consistent with the First Amendment, dictate the ownership of newspapers, websites, online platforms, and other privately created speech forums. The company says that the court should review the law using strict scrutiny, as we discussed. And this will be interesting because it seems like ByteDance does have a First Amendment interest in its editorial and publishing activities on TikTok. The company argues that the act clearly, quote, represents a content and viewpoint-based restriction on protected speech. The act discriminates on a content basis because it exempts platforms whose primary purpose is to host specific types of content. Product reviews, business reviews, or travel information and reviews. The act thus distinguishes favored speech, i.e. speech concerning travel information and business reviews, from disfavored speech, i.e. all other types of speech, including particularly valuable speech like religious and political content. And as if to prove their point, members of Congress publicly stated that they voted for the act because of political speech that appeared on TikTok. Representative Mike Flood said that TikTok should be banned because the kids are making videos about the literary works of Osama bin Laden. Representative Mike Lawler said that pro-Palestine propaganda on TikTok inspired protests on college campuses, and that was one of the reasons he was pushing the ban.
If you look at the postings on TikTok and the number of mentions of Palestinians relative to other social media sites, it's overwhelmingly so among TikTok.
Now, can the government prove a compelling state interest? Well, theoretically, yes. National security is a legitimate compelling state interest. However, quote, to do so, the government must do more than simply posit the existence of the disease sought to be cured. Rather, it must demonstrate that the recited harms are real, not merely conjectural, and that the regulation will in fact alleviate these harms in a direct and material way. ByteDance points out that the government's list of potential harms is speculative and theoretical. The company points to a House committee report that says TikTok could, quote, potentially be allowing the CCP to track the locations of federal employees and contractors. The same report raises the, quote, possibility that the CCP could use TikTok to control data collection on millions of users. Of course, this is why Senator Blumenthal thought the government should tell the public why the app posed such a serious threat to national security. But this lawsuit might force the government to finally disclose the concrete reasons it thinks the situation is so dire. And the complaint argues that the act is not narrowly tailored to address the government's interests. Here, ByteDance tackles the government's claim that TikTok is a national security threat, pointing out that, quote, Congress enacted these extreme measures without a single legislative finding. The company says that the parade of horribles that members of Congress fear are just hypotheticals. And since TikTok has been operating in the US since 2017, the court should expect the government to have concrete examples of how the app interferes with national security. And one way of narrowly tailoring things is what the states did. If the government's concerned about tracking federal employees, then you could pass a law that says you can't install TikTok on a government device. And ByteDance says it's invested over $2 billion in a project to work with the American government to deal with their privacy complaints. The complaint also argues that, quote, the act violates petitioners' rights under the equal protection component of the Fifth Amendment's due process clause because it singles petitioners out for adverse treatment without any reason for doing so. And similarly, the complaint argues that the act creates a, quote, unlawful taking of private property without just compensation in violation of the Fifth Amendment's takings clause. In both cases, the argument is that they're being punished and forced to sell without judicial process and by federal fiat without offering compensation. And the complaint does in fact allege that the act is an unconstitutional bill of attainder, using the same argument as Kaspersky and Huawei. The company complains that it's been singled out for punishment and treated differently than every other company with, quote, no public notice, no process for presidential determination that there is a significant national security threat, no justification of that determination by a public report, and submission of classified evidence to Congress, and no judicial review for statutory and constitutional sufficiency based on the reasons set forth in the presidential determination. So what happens next is anyone's guess. TikTok has good arguments, but I'd never bet against the US government when they're making national security arguments. So if you're an influencer who makes their money on TikTok, it's probably time to start budgeting and canceling your unused subscriptions, which you can do with today's sponsor, Rocket Money. Now, recently, I had a problem of trying to get a handle on all my subscriptions. Between my personal and professional subscriptions, I was paying out almost $20,000 a year. Yeah, I don't know when I signed up for Thai Clip of the Month, but being a lawyer is extremely expensive. But I hadn't been paying too much attention to what all I was subscribed to, and once I started to track my expenses, it was insane how much money I was spending on a monthly basis on services that I subscribed to but totally forgot about. But Rocket Money is an all-in-one finance platform that helps me be smarter about how I'm spending my money. It's a personal finance app that allows me to manage my subscriptions, lower my bills, and budget appropriately all in one place. And now that Mint.com is shut down, it's a wonderful replacement. I'm currently using Rocket Money to help me cancel all the subscriptions I wasn't using for apps I didn't need anymore now that Succession is over. Plus, it told me a little while ago that a service I was using increased their price by $100 a year. I had no idea. So I should probably be looking into that instead of reading this sponsorship. But Rocket Money has helped save its customers up to $740 a year, with over $500 million in total canceled subscriptions. It does that in part by fighting for lower bills. Simply by uploading a photo and tapping a few buttons, Rocket Money will negotiate your bills for you, from internet service bills to cable and phone bills. So join the 5 million members using Rocket Money today. Click on the link in the description or on screen to get started for free. And you can even unlock even more features with premium at a huge discount. So again, click on the link that's down below to get started for free. After that, click on this link over here for more Legal Eagle, or I'll see you in court.